Now we're back at this middle point, okay? Investigative detention. Now the investigative detention was something that law enforcement used, but it wasn't codified, it wasn't really recognized in the courts per se, along until the 1960s. And we had a little case called Terry versus Ohio. And in that particular case, a beat patrol officer, guy that knew his area, watched a couple of guys walking back and forth in front of a store. He recognized the behavior as being suspicious. He saw them walk back and forth past the store, kind of confer a few times, and then meet with a third party. And they wound up going past the store something like 24 times, okay, or 12 round trips. And they kind of met with this third party. The third party wandered off, and they kind of went back and forth some more, and then they met with the third party again. And the patrol officer, he stopped them to find out what was going on. He recognized their behavior as suspicious. They were targeting a particular store. I believe they were wearing overcoats, and maybe it wasn't terribly cold out. But the facts and circumstances that he was developing told him, looks like these guys are getting ready to rob the place. Okay, he was an experienced police officer. He wasn't just somebody straight out of the academy. He had experience. He had observable facts that he was able to articulate in court. And so what happened is we had the Supreme Court this case winds up making its all the way to the Supreme Court. And the Supreme Court, in an 8-1 decision, which is pretty good as far as decisions go, it was pretty clear that what the court thought. An 8-1 decision said that police officers have both the authority to stop and frisk people in certain reasonable circumstances, and that's what we're going to talk about. And that stopping of someone that does not constitute an arrest, but yet they're still not free to leave, it's going to be right here, the investigative detention. And that's what we're talking about. We're talking about our Terry stops, our investigative detentions. Okay? Stop and frisk. This is where we are right here. Okay? So, are you free to leave in an investigative detention? No, you're not free to leave. Okay? But what information do you need? Because if you have probable cause, you just make your arrest, right? So we need some level of information between probable cause and no information needed whatsoever. And that is a big loose area called reasonable articulable suspicion, or RAS. Reasonable articulable suspicion. And what that means is that you have to be able to articulate specific facts, specific behaviors that you know based on your training and based on your observations that the people there are engaged or about to be engaged or have just committed some type of crime. Okay? And it has to be reasonable. In other words, you can't come up with this bizarre set of circumstances to try to change the facts in your observations to match some reason to stop these folks. Okay? Reasonable. Are your facts reasonable to believe that somebody is getting ready to commit an armed robbery versus do those same facts you're kind of piecing together because you're trying to articulate that they're getting ready to steal someone's brain and turn someone into a zombie or something, okay? Something very bizarre like that, okay? So the reasonable aspect is would a reasonable police officer, would a reasonable man think that what you're observing matches the circumstances. Articulable, you have to be able to specifically articulate those individual observations and facts. Okay, and articulation, it's not just what you saw, but it's being able to recount that both in trial and also in your report. Okay, and then suspicion. Okay, something less than probable cause, but greater than just nothing or just a mere suspicion or mere hunch. Okay, if you see somebody you think is suspicious, that's going to be up here at the consensual encounter. If you see somebody you think is suspicious in a parking lot late at night, wearing all black clothes, carrying a crowbar in an area that you've had problems with prior burglaries, the business is closed. Okay, now we're talking about reasonable articulable suspicion. Can you articulate certain facts? Yes. Business is closed. It's after dark. Subject's wearing all black. You've had problems with prior break-ins in the area, and the subject's carrying a crowbar. Okay, I can articulate those facts. Now, with those facts and my knowledge of crime, is it reasonable for me to believe that the subject is possibly engaged in a crime, or possibly getting ready to be engaged in a crime, or possibly has just committed a crime? Yes, the crime of burglary, right? Okay, so that's reasonable articulable suspicion. Okay, with RAS, if I can articulate this, then I can detain them and they will not be free to leave. The length of my detention is going to be only that amount of time I need to dispel my fears or to develop additional information to develop probable cause. Okay? An investigative detention is not going to be an indefinite period of time. Usually we're talking about the space of a few minutes. Could be a couple of minutes, could be as long as maybe 30 minutes or so. Sometimes a little longer. Generally it's going to be a little shorter. Okay, the longer you run your investigative detention, the more likely you're going to wind up down here at an arrest. Okay, we'll talk about that in a second. Investigative detention. Okay, so are they free to leave? No. What information do you have to have? Less than probable cause, but you need reasonable articulable suspicion. Does Miranda apply? What do you think? Well, maybe. Whether or not Miranda applies is going to be very flexible in this circumstance. Okay? It's going to be dependent upon a great many things, not the least of which may be some state laws and state rules that apply. Okay? Generally speaking, if you have just detained somebody temporarily and they've not been detained too long and there's no coercion and there's not a big show of police presence, they're not in handcuffs or anything, generally Miranda is not going to be necessary. Okay, notice I'm saying generally because it's this big continuum. However, if you have someone that's detained for a longer period of time, someone that's detained maybe in a patrol car, somebody that you've moved from one location to another without their permission, maybe you've got a bunch of police officers on scene, holding shotguns or something like that. You have the subject wearing handcuffs. In that case, Miranda probably is going to apply. The idea with Miranda is whether or not the person believes they are in custody. One aspect of it anyway. If the person believes that they are in custody and that they no longer have the freedom to leave, which I understand they don't, but if they feel like they've been arrested, then chances are Miranda will apply. If, on the other hand, they don't feel like they've been arrested, then chances are Miranda is not going to apply. So, if you stop somebody, in the example I just gave, let's say I stop that guy with the crowbar after hours and everything. I stop him. I identify myself as a police officer. He willingly stops. He puts the crowbar down for my safety, that kind of thing. And he and I are standing there talking. I don't have him in handcuffs. I don't have him in the back of a patrol car. I don't have a bunch of other officers around him crowding him or anything else. I simply explain, hi, my name is Officer Johnson. I'm with the police department. And the reason why I'm stopping you is it's after hours, kind of in this area we've had some problems, and you're over here carrying a crowbar. What's going on? And he starts talking to me. Chances are that's not going to be a Miranda situation. On the other hand, if I see the guy and he turns around, he spins around, he's got the crowbar in his hand, so I draw down on him, I order him down on the ground, and my partners get there, we get him handcuffed, we stick him in the back of my patrol car, and I go over there and say, hey, look, I stopped you because you're walking around this business after hours with a crowbar, and then you spin around and you got this crowbar, and what's going on? In that case, is Miranda going to apply? Yeah, probably so. He's handcuffed in the back of my patrol car. He's had a bunch of cops pointing guns at him, right? Chances are he's going to believe that he is under arrest, and therefore he is probably going to need Miranda as far as the courts are concerned.